Yes, Mr.
Lord, 2 points arising before the short adjournment. The explanatory notes are departmental notes. And the other is, I don't think I've got anything to add to the comments I made to my Lord Sales before the short adjournment.
Thank you.
My next heading is solution, having identified the problem. And I'd like to address that in this way. Firstly, can I invite your Lordship, this is the quickest way to go to it, is to go to my written case. It's page 131 of the bundle. It's just the quickest way to get 2 references from 2 of the cases. So this is about the meaning of the word occupier. Firstly, Lord Nichols and Grayson Holdings said the concept of occupation is not a legal term of art with a single precise legal meaning, varies according to the subject matter, different shades of meaning according to the context. And then also Lord Mustall in Southern Water Authority, the occupy and occupied draw their meaning entirely from the purpose for which and the context in which they are used. Occupier has no fixed meaning. That's the first point I wanted to make. The second is, I mentioned before the short adjournment the case of Rossendale and Hurstwood properties. Can I take your Lordships to that very briefly? It starts at 2640 in the bundle. And it was about the meaning of the word owners in a rating statute, not the meaning of the word occupiers. You'll find at 2646 in the judgment of Lord Briggs and Lord Leggett, reference to, this is paragraph 10, page 2646, reference to the numerous authoritative statements in modern case law emphasising the central importance of interpreting ended legislation, identifying its purpose. A quote from Lord Bingham in Quinterval, the third line, the court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. And over the page, the statutory purpose and general scheme by which this is to be put in effect are of central importance. The notion of words having a natural meaning is not always very helpful and certainly not a starting point. And then the reasoning in the judgment, if I could start at page 2659, the third line, perhaps unsurprising, the circumstances of the judge and the Court of Appeal did not adopt a purposive approach to interpreting the relevant statutory provisions and consider that the owner, as defined in the section, must invariably, and even on the assumed facts, be identified as the person who's entitled to possession of the hereditament as a matter of the law of real property.
So which paragraph?
I'm sorry, my lord. Paragraph 52.
52, thank you.
I was just starting from the third line and read 4 or 5 lines down.
Yes, thank you.
And then over the page, just before letter B, Lord Justice Henderson concluded that legislation is not amenable to a wider purposive interpretation which could allow scope for the Ramsey approach to operate. And then if I could go on to paragraph 59. So in the present case, we consider the words entitled to possession in section 65 as the badge of ownership triggering liability for business rates are properly construed as being concerned only with a real and practical entitlement, which carries with it particularly the ability either to occupy or to confer rights of occupation. And then if I can go over the page again to paragraph 60, just above letter E, a recognition that section 65 is speaking of entitlement to possession which vests in the person concerned a real and practical ability either to occupy the property or to put someone else into occupation of it is a purposive interpretation which achieves some coherence between the language of the statute and its purpose in identifying the owner of an unoccupied non-domestic property as the person who is liable for business rates. And then finally, in paragraph 61, between letters G and H, there's a sentence starting the fact that the law of real property may not provide a reliable guide in an unusual case of the present kind is not, in our view, an objection to our preferred interpretation. So I refer your lordships to that simply by way of analogy. It's considering a completely different word, but as the approach that's appropriate to adopt here. I've already made the point earlier that these code rights are not property rights in any event, but they are, as my learned friend describes them, a sui generis statutory creation. The relevant expression here, although we talk about occupier, the relevant expression is occupier of the land, because that's the way that, because that's the expression one finds in paragraph 9, rather than occupier. So far as land is concerned, there are two paragraphs that provide some assistance of that in the new code. And can I invite you to look firstly, page 1871, which is paragraph 101. And paragraph 101 states, the ownership of property does not change merely because the property is installed on or under or affixed to any land by any person in exercise of a right conferred by or in accordance with this code. That deals with the what would otherwise be the real property point, because as a matter of real property law, if you attach a chattel to land, at least if you attach it sufficiently, it becomes, as a matter of law, part of that land. Then if you're a tenant, you've got nevertheless a right to detach it and remove it at the end of the term. But whilst it's attached, it is part of that land. I don't know, I imagine the position is the same under Scots law.
Very similar.
Enormously ignorant on that front. The other provision that one has is the definition of land in paragraph 108, page 1875, where there is a definition of land where it specifically said that it does not include ECA. We know, because I've taken your lordships to it earlier, that ECA can include structures, and that can include buildings whose primary purpose is for the purpose of code rights. So even a building put on the land, erected on the land by the operator, is not going to be treated as part of the land, even though, as a matter of real property law, it would do so, and that's because of paragraph 101 and paragraph 108. So, it is clear that Parliament intended to make a distinction between ECA and land, and make the point that ECA was not part of the land. Why, one wonders, did they want to do that? After all, it doesn't matter that it becomes part of the land. The operator would have a right to remove it at the end of the term. It doesn't matter from a real property context. So what was the reason for doing so? The reason we suggest for doing so was to distinguish between control of the ECA and control of the land. And therefore, since occupation requires sufficient control of land, the point that was being made was that control of ECA is not to be treated as control of the land. Now, I quite appreciate that in a real property context, you don't need to attach things to land and for them to be part of land in order to be occupation of land. If I have a field and I've got lots of sheep in it, and they're my sheep, they are chattels, and I'm in occupation of that land, even if there are no buildings at all, in a real property sense. But we're not concerned with the real property sense of occupier here. And what we suggest is that we get a steer from 101 and 108 that supports the conclusion that one in any event needs to come to in order to make sense of the code, that an operator with ECA on the land can't be treated as the occupier of the land. And then Lady Rose made a point, if I recall, this morning about tenancies and what the position might be then. And I referred, I think, to the anti-avoidance provisions. And they're contained in paragraph 100 of the code. They're rather oddly formulated, page 1871. So they say, subparagraph 1, this code does not affect any rights or liabilities arising under an agreement to which an operator is a party. That's the starting point. But subparagraph 1 does not apply in relation to paragraph 99 or parts 3 to 6 of the code. So the conclusion is, therefore, you cannot get out of parts 3 to 6 of the code by agreement. That it is intended as an anti-avoidance provision, we get, well, firstly, we say is obvious. The Court of Appeal agreed, Ashlock, paragraph 46, page 741. So there's common ground on that. So it's quite clear, therefore, that a contractual provision which purports to prevent the operator making an application under paragraph 20 would be ineffective. That's obvious. We say so also is an agreement designed to have that effect by purporting to make the operator the occupier of the land if, by being occupier of the land, it wouldn't have a right under paragraph 20. So
you're saying that they can't agree which of them is going to be the occupier of the land for the purposes of the code. They either are or aren't, according to what that term means and how it applies to the facts, because of paragraph 100.
Well, what I'm saying is that the intention of the code is that the operator should be able to have access to paragraph 9 to paragraph 20. That's the clear purpose of the code. It's the only way in which you can make sense of all the provisions I dealt with before the short adjournment. That is, we find support for that in 101, 108.1. I'm not suggesting you simply construe those provisions and therefore they mean that, but those provisions are in there for the purpose of control. And if it's put against me, well, that may well be that therefore, and this I think is Malade's point before the short adjournment, do we need to say anything more than the fact that you ignore the fact that there's ECA on the land? And I can envisage circumstances where you do need to go further than that, because it's common for code agreements to amount to leases. And so in a real property sense, they grant exclusive possession if they're a lease. And if you're using the premises with exclusive possession, you're going to be considered the occupier in a real property sense. And what we're saying is that paragraph 100 indicates that Parliament intended that one should not be able to avoid what would otherwise be your ability to access the code by the fact that you're granted something that amounts to a lease with exclusive possession as a matter of property law. Because the reality is that by far the majority of these agreements are granted by leases. Something which is referred to in the Law Commission report. They were well aware of that. There's nothing new or surprising about that at all, and it happened under the old code too. So we say that if one looks at paragraphs 101, 108.1 and 100, they offer support to the purpose of interpretation that we invite the Lordships to adopt, in which an operator cannot be treated as an occupier of the land. There is some further incidental support to that, but I'll come to this later on when I deal with the second part of my argument in paragraph 105.
So can I just be clear? Your argument on paragraph 100 is if there's a lease, we ignore that lease.
Yes, for the purposes of considering
Occupation.
of whether the phrase occupier of land for those purposes. Obviously not for other purposes, but for those purposes, yeah.
In these cases, I'm right in thinking, aren't I, that the operators were all given leases at some stage?
Yes.
I mean, we may now be into tenancies at will and
so the
periodic tenancies or whatever, but they're all situations of leases at some stage
indeed.
when the ECA was there. And you're contrasting. So if you've got a rooftop, I mean, I'm just thinking about your station example.
Yes.
You've referred to a couple of times. What's going on there exactly? There's no lease.
There's no lease, or at least it won't be a lease. It won't be more than a lease of rights, of easements,
No.
rather than a lease that gives exclusive possession of a corporeal hereditament. So and it's important to understand all junctures here, and I'm sorry to have to keep emphasising it. It's not the case that all operators will be in occupation, even on my learned friend's argument. So some would, some wouldn't. We say they should never be treated as such.
But you're saying that the Court of Appeal's reasoning is that wherever you have ECA on land, you're an occupier of that land?
No, they didn't say that. They said that if you have ECA on the land, and if you have sufficient presence and control of the land to be an occupier in an ordinary real property sense.
As by lease?
Yeah, for example, occupation matters for under Part 2 of the Landlord Tenant Act 54. Unless you're in occupation at the contractual term date, you don't have continuation rights under Part 2 of the Landlord Tenant Act 54. What they're saying is you apply that test to the question of occupation. It requires, so it's not every exercise of any element of control of land that amounts to occupation in a real property sense. There has to be a sufficient degree of control. And that's a question of fact and individual case. It obviously depends on the type of land in question. And you don't need to do so much if it's open moorland as you would do if it's central London property.
The issue is whether you take into account the control that arises because you've had to fence it in for security and safety, and you're the only one who can go in there because of the ECA, or that is the ECA, whether you take that into account in deciding whether that broader test of occupation is met or not.
Indeed. And if we were going to be technical about this, the fence would also be ECA, I think.
Yes, that's what I mean, yeah.
But whether it's treated or not, it's done for the purpose of protecting the rather more important ECA, the mast and the cabinets and all that. So we say that all should be ignored. And if it's the case that there's a lease, that doesn't make any difference either. And that is the purpose of interpretation that we invite your lordships to make, which finds some support in these provisions.
Well, how does it, if it does, actually translate into the code? Are you saying that in paragraph 105(1), when it says references in this code to an occupier of land, if the occupier of land for the time being, that means R2, the occupier of land for the time being, excluding the operator for this purpose? Or,
yes.
That's your construction, is it?
Yes, yeah. Lord, that's precisely what I say. And I was going to take your lordships very briefly to paragraph 105, which is page 1874. I'll come back to it.
Just before we do that,
I'm sorry, my lord.
I was just questioning whether the fence would be part of the ECA under paragraph 5, which is page 1814. Would it be a structure designed or adapted for use in connection with the provision of an electronic communications network?
In my submission, I must be quite candid. I've not thought about this point before a moment ago. But I, thinking on my feet, my submission, it's a structure, firstly. It's designed for use in connection with the provision of ECA because it makes the mast secure and safe. So I think the fence is actually part of the ECA.
Presumably these masts have a lot of copper and other valuable metals in them.
Yes.
You need to keep people out from stripping them.
I think there are things like that. I think there are also issues about radiation as well. I'm not a great expert of that, but I think it's not a good idea to get too close to them. But yes, there's security issues as well. I imagine they contain some valuable things in there.
Yes, thank you.
So I was going to just touch on paragraph 105. I say I'll come back to it when I'm hoping very shortly I get to my second argument. But this is as good a place as any just to indicate that there's quite an elaborate definition of occupier. And the reason for that may well be because if one is excluding from the operator from that, then sometimes that we may need specific provision to deal with. If it's not the operator, who is it? So it works as a cascade in 3 steps. Step 1 is 105.1, the occupier of the land for the time being. And then if it's unoccupied, subparagraph 5, the next element of the cascade is 6A, the person of any who for the time being exercises power of management or control over the land. If there's no such person, the third element of the cascade is every person whose interest in the land be prejudicially affected for the exercise of the right in relation to the land. So the only point I make at this stage, I say I'll come back to this, is it's quite an elaborate provision, perhaps to deal with the fact that if it's not the operator, then an inquiry needs to be made as to who it is. Finally, I was going to address, I hope very briefly before I come to my second argument, some of the objections that AP Wireless have raised to the submissions that we are making, some of which I've already dealt with. Firstly, they say we're only concerned with the transitional provisions. I think I've said I've dealt with that. Yes, the 3 cases before your lordships are effectively transitional provision cases, but the implications go much further than that. The problems under 26, 27, 40 sub 8, 37.4, additional rights during the term, and voluntary renewal of a Part 2 or Part 4 agreement, if not by order under Part 5, are all problems that have got nothing to do with the transitional provisions. Secondly, my learned friends say, if I'm right, there's a conflict between the 54 Act and Parts 2 and 4 of the Code, and I want to address that very briefly, if I may. And I've already, I think, laid the groundwork for part of this, which is this. Part 5 does not apply, the Part 5 continuation provisions don't apply if there is a subsisting agreement that's 54 Act protected. That was paragraph 6.2 of the transitional provisions. I'm happy to go back to it, but I think we looked at that this morning. They do apply if that pre-existing 54 Act protected tenancy is then renewed under the 54 Act, because at that point, Section 43.4 of the 54 Act says the 54 Act no longer applies, and the intention must have been that it comes within Part 5. The only problem is, on my learned friend's argument, it's difficult to see how it comes within Part 5, but I dealt with that this morning. So the purpose is to ensure that at any one time there's only one continuation mechanism. My argument does not affect that at all. That's the first point that I would make. The second is this, that although Part 5 is disapplied by the transitional provisions in the case of a subsisting agreement that's 54 Act protected, it's nevertheless an agreement within Part 2. It might just be worth going back to that, page 1877. So we imagine this as subsisting, an agreement in writing that's a 54 Act tenancy as at 28th December 17. It comes within the definition of subsisting agreement in paragraph 1.4. It falls within paragraph 2.1. It's within Part 2 of the Code. However, over the page, paragraph 6.2 says Part 5 doesn't apply to it. So it's important to note, therefore, that a 54 Act tenancy does have the benefit of the special characteristics, the no restrictions on assignment, the sharing, the upgrading, for example. The other point to note, if your lordships are still at page 1878, although I accept the point doesn't go very far, is that although Part 5 is disapplied, Part 4 is not expressly disapplied. So the learned friend can't say, look at the transitional provisions, they are inconsistent with my case. The other point to note is that an operator with a 54 Act protected tenancy is not required to renew under the 54 Act. If it agrees with the landlord, it can agree to enter into a new tenancy, which as a matter of property law will amount to a surrender of the existing 54 Act tenancy and the grant of a new 54 Act, and the grant of a new tenancy, which will not fall within the 54 Act, but will fall within Part 2, at least on my case, not in my learned friend's case. So a tenant with an existing 54 Act tenancy as of 28 December 17 is not required to use the 54 Act. It can voluntarily agree with the landlord a new tenancy, and then it's within Part 2 and has the benefit of rights of renewal under Part 5. Secondly, if the landlord doesn't agree to a new tenancy, the tenant can bring the tenancy to an end. If it has a fixed term, it can do that on 3 months' notice to expire before the end of the contractual term, or thereafter if it's continued. That's Section 27 of the 54 Act. I wasn't going to go to it specifically. If the landlord serves a Section 25 notice, so Section 25 of the 54 Act, terminating that tenancy, and an application is made for a new tenancy by the landlord, the tenant has a right to get that application dismissed under Section 29(5) of the 54 Act. Or if the order for a new tenancy is made, the tenant can get that order revoked. See Section 36(2). Your lordships have got all the relevant sections of the 54 Act in the authorities bundle. I'm happy to take your lordships to it, but I'm conscious of the time. So the general point I'm making, therefore, is that a tenant is not required, in the absence of agreement, to have a new tenancy at all. It can bring it to an end. If it does bring it to an end, it can make an application for rights under the code. The question I ask rhetorically is it really the case that in order to make an application under the code, it's got to move its ECA off the land, then make the application, wait for the application to be granted, and move it back on again? That would seem a fairly ridiculous conclusion. So we say there's nothing saying that pre-existing 54 Act tenancies have to renew under the code. They can do so voluntarily. And if they bring the 54 Act tenancies to an end, they should be able to do so under Part 4 as well. The position, I just want to highlight one point, which is the position of a periodic tenant who is in a very unenviable position. A periodic tenant under the 54 Act can bring his periodic tenancy to an end by notice to quit. Section 24(2) of the 54 Act says so. But if he does that, he won't have any right to renew under the 54 Act. Not a problem, if I'm right, can apply under Part 4 of the Code. But neither can a periodic tenant invoke the mechanism to apply for a new tenancy under the 54 Act itself. It simply has to wait there. So he's got two choices. He can bring that to an end, but if it wants a new tenancy, it cannot use the provisions of Section 26 to apply for a new tenancy, which only apply to tenancies with fixed terms. So that periodic tenant can't force a 54 Act renewal and can't get into the code at all.
Unless he moves all his...
Unless he moves all his stuff off. So we say there's no reason why Part 4 should not apply in those circumstances. The tribunal has a discretion under Part 20. I've already made that point. I've taken your lordships to the difference in wording, showing that may means may here, it doesn't mean must. One can see that this may be, unlike the usual case where the first condition and second condition are met and the court will almost inevitably grant rights under paragraph 20, under paragraph 21, this may well be a case where it may really exercise its discretion not to. Because in a case where a tenant has rights under the 54 Act, one would expect that the Upper Tribunal, if an application is made under paragraph 20, will say to the operator, well, why didn't you apply for 54 Act rights? And will want a good reason for that. And there may indeed be a good reason. Under the 54 Act, there are restrictions on the ability of the operator to get different rights. There's a test in a case called O'May and City of London Real Property that requires one to show a good reason to change the terms of the tenancy. So therefore, if one wanted to get some additional right, that may be more difficult under the 54 Act than under paragraph 20. That might be a reason why the tribunal might accede to such an application. Neither does it give rise to any problems in practice. If there are both proceedings for renewal under the 54 Act on foot and a paragraph 20 application on foot, then the Upper Tribunal judge can hear the county court proceedings at the same time, or alternatively the Upper Tribunal can transfer to the county court. The Law Commission in its report specifically envisaged that might happen. Again, I'm not going to take your lordships to it, but that's 9.46 of the Law Commission report. I'm afraid we don't have it in the bundle, but I think it was handed up separately, or if not, was going to be handed up separately. And if what is sought is a code agreement that replaces a existing 54 Act tenancy, as in the Ashlock case, then if the paragraph 20 proceedings were started first, there's no reason why the order couldn't be made conditional on the tenant giving up its 54 Act rights. And alternatively, it's arguable that the new agreement imposed under paragraph 20, if the tribunal decided to do that, would have the effect of bringing the existing 54 Act tenancy to an end by deemed surrender. Whether it does or not is perhaps a debatable point of law. It clearly would if done voluntarily. Whether it does if a code agreement is entered into pursuant to an order under paragraph 20 is perhaps a more difficult question. So we say there's no problem at all with Part 20 applying in the case of an operator with 54 Act rights. Final point I think I wanted to deal with under this, under my first argument, is the another argument that AP Wireless raised is that on our case there's a conflict between Parts 4 and Part 5 of the Code. And I think I need to deal with that briefly. Again, make 2 points at the start. Firstly, that under paragraph 20 there is a discretion. The court doesn't need to make the order. The other point, and it may just be worth going back to paragraph 20 on, which is page 1821, is what it's to be clear about what paragraph 20, the order that is made under paragraph 20. Paragraph 20, page 1821, applies where the operator requires a person to confer a code right. And paragraph 23.1, the order that's made is one which gives effect to the code right. So paragraph 20 is about conferring code rights. Part 5, of course, is about terminating rights and changing rights, as well as adding on new rights. So the scope of the two is quite different. There are perhaps three possibilities to consider. One is the landowner seeks to terminate an existing code agreement that falls within Part 5 under paragraph 31, serves notice to terminate, which is going to be successful if it establishes, if and only if it establishes one of the grounds. If it does establish one of those grounds, it's difficult to see how the court would ever grant an application under paragraph 20. It would dismiss that summarily. Learned Friend's complaint about this is, well, yeah, but in theory we can make that application and it would give us a second bite at the cherry. But we are entitled to a second bite at the cherry because the code specifically envisages that. That was paragraph 40, subparagraph 8. You'll also recall we looked at that this morning. This is in the context of Part 6, where there is a right of removal, including a right that is arisen because of a termination order made under 32.4. Nevertheless, the court will not order removal if a paragraph 20 application has been made. So that's the answer to that point. The other possibility is that either the operator or the site provider gives notice not under paragraph 31 but under paragraph 33, seeking a modification or a new agreement. Now, as to that, my learned friend says, well, even a voluntary agreement, a voluntary grant of a new agreement is not effective to bring an existing agreement to an end under paragraph 30. That depends on some rather fine questions about the precise circumstances in which paragraph 30 operate and whether they prevent surrender and re-grant or not. My submission, they either do or they don't, but it doesn't affect the fact that the court simply has a discretion under paragraph 30. It's not going to operate under paragraph 20. It's not going to use that discretion as there was not a good reason to go under Part 5 instead. In any event, it is clear that paragraph 20 can't be used if all that is sought is the modification of existing rights. It can only be sought in respect of the grant of new rights. The third possibility is the operator seeks additional rights. It can do so in the term under Part 4. In my submission, we dealt with that earlier. It's right, they can also be sought after the end of the term under Part 5. But if refused under Part 5, it seems extremely unlikely they'd be granted under Part 4. In any event, and this is perhaps the most important point of this whole section, an operator will use Part 5 if it can, rather than Part 4. For this reason, Part 5 specifically envisages the grant of additional rights, and more importantly, under Part 5, you don't need to get through the hurdle in paragraph 21. So Part 4 is a more difficult route for operators who will not use it if Part 5 is available. In any event, the court has a discretion. This is not a problem in practice.
The main point put against you is that Part 5 involves 6 months' notice and Part 4 only requires 28 days' notice. So why do you say that Part 5 is more difficult?
Well, we say part 4 is more difficult because you've got to go through the paragraph 21. Right. You've got to satisfy the paragraph 21 hurdle. I accept that there's that difference in timing requirements, lady, yes. I do accept that. But if we're talking about additional rights, if I'm right on what I said this morning, maybe I'm not, but if I'm right on what I said this morning, then the code, under the code, one does have a right to seek additional rights during the term on 28 days' notice under paragraph 20. I accept that that is one of a number of orders that can be made under Part 5. But the other orders that can be made under Part 5 can only be made, many of them can only be made under Part 5, in relation to modification of existing rights, in relation to termination of existing rights, for example. I dealt with what I call blue-on-blue applications in answer to some questions from my Lord Burrows before the short adjournment. And I don't think, unless I can assist further, there's anything I wanted to say on the first argument, and I was then going to move on to the second argument, which I'll do much more briefly.
Can I just ask, isn't there something rather odd, at least conceptually, with your argument in this sense that let's assume we've got an operator under a lease who has been given code rights but has not yet installed any ECA. There's no equipment.
Yes.
Before the installation of the equipment, I understand your argument to be that that operator would be an occupier, but once the ECA has been installed, they become a non-occupier. Is that wrong?
That's not my argument,
yeah. Right,
Lord, because before the operator has installed the ECA, he's got no control of the land whatsoever.
He's a leaseholder.
It's a leaseholder, but he's not present on the land at all. So, if he has a lease, the fact that one has a lease of a piece of land, excludes any reference to operators here. The fact that one has a lease doesn't mean one is the occupier. There's a difference between possession and occupation. But what we're saying is that an operator is never to be treated as the occupier of the land, so that even if the operator is ECA on the land, and even if the ECA is on land pursuant to a lease, is nevertheless not to be treated as an occupier of the land for the purposes of the code.
And you could still get an interim period, as my Lord was putting to you. I mean, suppose you've got all the surveyors going on the land and the personnel of the operator before any equipment is put in.
Yes.
So you would say, all right, they are in occupation of the land according to an ordinary test.
Yes.
How do you address that? I'm not sure if I followed your answer.
What I would be, sorry, I've not been terribly clear. What if there were surveyors and the like on there, they would be there exercising code rights. So I think what I'm saying, perhaps not put this as clearly as I should have done, that an operator exercising code rights is not to be treated as thereby the occupier of land.
Why wouldn't they be exercising tenant rights, on my Lord's example, if there's a leasehold?
Well, they would. Well, if they've got rights under the rights pursuant to a code agreement, then obviously they're exercising code rights. Otherwise, I agree, they're exercising rights as tenants, but in connection with ECA. The purpose of them doing so is in connection with the future installation of ECA on the land.
But I think you're saying that it's not the installation of the ECA which then magically removes the occupier indicia from the operator.
No.
No, it doesn't, or no, you disagree with it.
Sorry, I agree with you.
Right.
I agree with your ladyship.
I see. So it's the fact of that for this purpose, he may be an occupier for all sorts of other purposes, whether because of the lease or because of the installation of the ECA, but he's not an occupier for the purposes of the code,
No.
either because of the rights he has under the lease or because of the installation of the ECA. Is that right?
That's right.
So you can have a 1954 Act lease which confers code rights, and for some purposes that can make him the occupier, but for code purposes not.
For code purposes, not, yes. What's occupier in one statutory context or one legal context is not the same as what's occupier in another context. I mean, the classic case is a squatter, considered an occupier in some contexts, but not in other contexts. So we say if the reason that the operator is physically present or is exercising any rights of control over the land is in relation to the operation or intention to operate its network or infrastructure system. In other words, if it's for one of the statutory purposes in paragraph 4 of the code, and that is the reason that rights are being exercised, that's the primary purpose for which rights are being exercised, then that presence and that control is to be ignored in considering who is the occupier of the land within paragraph 9 and by extension paragraph 20.
So you are marginally amending the main submission you put forward, because I think you told us originally it was all to do with whether or not you've got ECA on the land, but now you're expanding it to include exercising code rights, as I understand it.
Your Lordship is absolutely right. The reason is I've been concentrating on the central case, and the central case where an operator might be considered as being in occupation, because not all operators are going to be considered to be in occupation, are going to be cases where they have ECA and they've got a fence around it. But I accept that it's possible that there might be circumstances, depending on the context, in which they might, in a real property sense, might be treated as having sufficient presence and sufficient control to be treated as occupiers, in theory, before the ECA is put on there. Of course, if the fence is ECA, one can imagine a case where the fence is put in before they put in other things, but if the fence is ECA, that perhaps deals with that point. But it's perhaps difficult in practice, although taking the example that my Lord Sales was referring to earlier, that may actually be difficult in practice to think of cases where an operator would have sufficient presence and control to be treated as an occupier in a real property sense, but where it didn't yet have ECA on the land, at least having fenced it. I can't offhand think of such an example, but in answer to my Lord Borough's point, I accept that in theory the position is a little wider than the central case that I put, although, and not want to limit myself in case there are examples that I can't otherwise think of, but I think really the question is, rather than is the ECA on the land, rather than that being the precondition, The question is, are you exercising rights, the primary purpose of which is as set out in paragraph 4? That is the purpose of providing an operator's network or providing an infrastructure system, which are also defined expressions.
But when you say that the operator is not the occupier, I think you mean not for either being a counterparty on either side of the agreement, so that in Cornerstone, where it was suggested Vodafone is the occupier, so Cornerstone should have applied to Vodafone for the grant of rights, you would say Vodafone is not the occupier either in order to apply under paragraph 20 nor in order to grant rights under paragraph 20.
Well, the application under paragraph 20, if I'm right about 9 being attached to 20, is an application against the occupier.
Yes.
So my learned friend is right. Cornerstone should have made an application against Vodafone, which we say is slightly odd, given Vodafone have got no rights there, etc., etc. So the question is, who is the person who is going to confer rights? That can only be the occupier. So, of course, what matters is whether the operator is treated as the occupier of the land for the purpose of the person conferring rights. That's the only context in which we need to consider that question.
I wonder whether it's so easy for you to slip from focus on the ECA to focus on the activities of people on the land, because part of your submission in relation to the ECA has focused upon paragraphs 101 and definition of land in 108.
Yeah.
And you say, well, if the ECA is not part of the land, that shows that occupation through the ECA doesn't count.
Yeah.
But I mean, if one was following the logic of that argument, wouldn't you expect to see something equivalent in relation to occupation through methods other than installation of ECA, to make the position clear?
I think I would say two things about that. Firstly, I'm still struggling to think of a practical example where someone would be considered as being an occupation which didn't have ECA on the land, and who wasn't an occupation because of the ECA on the land. So that's one point. The other is...
I say so just on that.
I'm sorry.
I mean, there will be a phase where the person that's wanting to erect ECA will physically send people out onto the land before they put up anything at all. The surveyor to decide what to put up, the builders bearing stuff that they want to put up but they haven't put up yet. It may be quite a short period of time, but I'm not... For myself, I'm not struggling to see that there will be such a phase.
Lord, I can see in reflection that's right. When think of, on day one, they'll go out to the land, mark it out with some stakes or whatever, or however they're going to do it, with some spray paint or something like that, something that doesn't involve a structure, and they'll wander all over it, and one can see, yes, that might amount to occupation. The reason it's unlikely, one would have thought, to be a practical question is the question is, who is the occupier of the land at two dates? The date that an application is formally made under paragraph 20, and at the date that the order is made under paragraph 20. Now, one can see after the order being made under paragraph 20, that might happen. But the question is, at the prior date, which will happen in circumstances either where there's no one on the land at all, in which case no problem, or in circumstances in which there's existing ECA on the land, either with no rights or with temporary rights or with interim rights. So one wonders whether it's, from that point of view, really likely to be a practical issue if one's considering the question at those two dates.
Just coming out of that, I mean, in theory, one could have a change in occupation or control between the time when you make an application and the time when an order is made. Does does the code deal with that? It may be too obscure a problem for them, the drafter, to have thought it necessary to deal with that. I mean, I would have thought that the critical date was likely to be when the order is made, because that's when the agreement is imposed.
Right. Well, what it says, page 1821,
Thank you,
is that the operator may, paragraph 20 sub 2, the operator may give the relevant person a notice in writing. The relevant person is the person to confer a code right. And then paragraph sub 4, 20 sub 4 over the page, an order which imposes on the operator and the relevant person. So clearly the date of the order matters. It would appear that the date of the application matters too.
Well, wouldn't there be tribunal procedures for substituting a party
Yes, I'm sure.
to the proceedings if ownership of the land changed hands in the meantime?
Yes. But one would have thought if those 2 dates matter and if there's a change between those 2 days, then there would be a valid paragraph 20 application. One substitutes in the new owner. And indeed, I think that's what will happen with Gateway Properties in the Ashlock case.
I may be missing something here, but this all seems to me to be tinkering around the edge of the question, and either you're right on the basic point or not, and if you are, then these sort of peripheral things can be worked out, and if you're not, they don't arise anyway.
Lord, I would respectfully agree. The other point, if I could just make one further answer to my Lord Salisbury's point, is that Lordship's absolutely right. I did refer to paragraph 101 and 108 and the reference to ECA. I am not suggesting that paragraph 101 and 108 get you directly to the conclusion, because they simply say ECA is not treated as part of land, right? And I think I made the point about sheep in a field, that you don't need to have things that are part of land to be the occupier of land. But it's an indication that the Parliament intended that the operator, person who would have the ECA on the land in due course, was not to be treated as the occupier. And unless there's anything else, I'm going to move on swiftly to my second argument, which I'm going to promise to do within the next hour.
Well, if you need to extend your opening submission, you can take the time off your reply.
Lord, I'm grateful. I have had a word with my own friends about that over the short adjournment. Certainly my own friend Mr. Seatler and I think that we can be rather shorter in our reply, and we will certainly ensure that Mr. Pinemont has all the time that he needs.
Thank you.
So I'm going to go on to the second argument, which is this. The Court of Appeal decided that occupier required physical presence and a sufficient right of control. Physical presence and sufficient factual control. We say it also requires a right of control. What occupier means depends on the context. I've already taken your lordships to the extracts from Grayson and P&O Holdings and Southern Water and Nature Conservancy Council in my written case, and I won't go back to those. There is one case, again, I'm not going to take your lordships to it. It's called Woodcock and Southwestern Electricity Board, and it's page 2969 of the bundle, which is simply an example of a case where an occupier did not include a squatter. It was a case where there was a duty of an electricity company to supply to and these are the words, occupier of any premises, and it was held that didn't include squatters. Although they had factual control, they didn't have a right of control. And I don't go to it because it's simply an example. And so it can mean that, and it all depends on the context. We say and similarly to our first argument, that the provisions of the code, when considered carefully, indicate that what is required here is not just factual control, but a right of control. And the principal provision we rely on in support of that is paragraph 105 of the code, which is page 1874. And Lordships recall, we looked at this briefly, and the definition of occupier has a cascade with 3 elements. And first point we say is this, is that the second element of the cascade requires rights. It's not just about facts. It says the person who for the time to time being exercise powers of management and control. And we say powers indicates rights.
Well, that's a point against it, isn't it? Because you only get there after you've decided the factual question.
Well, Lord, we say not. And the point that your Lordship has just made, of course, is precisely the point that was made against us in Compton, the Court of Appeal, paragraph 54. I think it is. But we say not for this reason, that it would be an odd thing if the first element of the cascade was nothing to do with rights, and the second element was to do with rights, especially when we see that the third element is also to do with rights. So the third element is about people who've got an interest in the land and therefore have rights because of their interest in the land. And we say that the difference between the first element of the cascade and the second element of the cascade is this, that not every amount of control amounts to occupation. There has to be a sufficient degree of control. If the degree of control is sufficient to amount to occupation, then you're in the first element of the cascade. If it's insufficient to amount to occupation, nevertheless, if there is some power of management or control exercised by someone, that person comes within the second element. And then if there is no right of control exercise at all, it's the person with the property interest. So we say that paragraph 105 is consistent and indeed supports our submission because one can easily read that, and this is, we say, the right way of reading it, as saying that all 3 elements require rights, and they're about different types and degrees of rights.
So you're saying that in order to fit in 6A and become an occupier pursuant to that provision, you must already have been decided not to be an occupier in 105.1 because 6A only applies if the land is unoccupied.
Absolutely. Absolutely.
So you say to occupy it under the first tier in 105.1 must require something more than powers of management or control, because then the land wouldn't be unoccupied.
Well, I would put it the other way round, which is, if I'm right that occupation in its ordinary sense under the first element requires a physical presence and sufficient degree of control as to amount to occupation, given that not every degree of control amounts to occupation, then that gives sense to the second element of the cascade, because what it's talking about is powers of management or control which are less than sufficient to amount to occupation. So there is, just to make the point, that not every amount of presence and control is sufficient to amount to occupation. Can I take your lordships to a case called Wandsworth London Borough Council and Sing? It's page 2833. So this was a question of whether there was occupation within the meaning of the Landlord and Tenants Act 1954, Section 23, and whether the local authority was in occupation. And you'll see from the holding that it was held that the council had shown more than merely passive management of the site and had exercised a sufficient degree of presence, maintenance and control of the land. And if I go on in the judgment to 2840, so 2840 in the middle of the paragraph, it's about a dozen lines down. Lordships may see the reference to a case of Groveside Properties and Westminster Medical School. It says that the fact might make it more likely the tenant could be shown to be in occupation for the purposes of Section 23, but that couldn't be enough unless there's sufficient presence and control. And then at 2840, the paragraph starting a little below halfway down, the judge, in my view, listed the factors which he regarded as relevant. This is to the occupation in relation to expenditure, etc., etc. He listed them to understand it in the process of his reasoning that led him to reject the contention there that there was here merely passive management, and to observe that this valuable open space required the degree of attention, maintenance, control which he had described. His judgment shows that he realised clearly the necessity for the tenant to prove such extent of presence and control of and by the servants or agents of the council as can be held to amount to occupation under the section. So I take your lordships to that simply to illustrate the point that not every amount of management and control necessarily amounts to occupation.
But presence, in this case, is a factual matter.
Yes.
And that's not your test.
No. Well,
you're saying it's a matter of rights, is that so?
I'm saying it requires both rights and a factual manifestation of those rights. What the Court of Appeals said is it required physical presence and a sufficient factual control. I say it requires physical presence and a sufficient factual control and a sufficient right of control. In other words, that the factual control has a right underlying it.
Okay.
So it's something. It's not only what's in subparagraph 6A, but something on top of that, namely physical presence and actual control.
Lady, no, we are saying that the test of what amounts to occupation depends on the context. We are saying that occupier here means not just physical presence and factual control, but physical presence and factual control and a right of control.
Yes, but does it require all three, or only?
Yes.
Yes,
right. So
that's our case.
That's your case.
That's our case, as indeed it sometimes does a common law. I mean, see the squatter case that I mentioned, but didn't take your lordships to Woodcock and South Western Electricity Board. There, it required factual control and a right of control. In that particular context, we say that's what it requires in this context. Indeed, if your lordships were to look at, I'm not inviting you to do so, but if your lordships were to look at the Court of Appeal judgment in Compton, Lord Justice Lewison has quite a long passage going through the meaning of occupation and how it means different things in different contexts and refers to quite a lot of different cases. And we go, yeah, we agree with all that analysis, but it does mean these different things in different contexts. The question is, what does it mean in this context? In some context, it can require not only factual control, but a right of control. In some contexts, it only requires factual control without any right of control. We say it makes sense here that includes a right of control. We say that is consistent with and in fact supported by paragraph 105. It would be an odd thing if the second and third elements of the cascade required rights, where the first element of the cascade does not require rights. That would seem odd.
Might it not be said that this submission is rather in tension with the rationale given for the scheme of the code, and indeed the old code, by Sir Andrew Morritt, I think in the Bridgewater Canal case, that the focus on occupation is intended to make it very easily workable, the scheme very easily workable, because one just goes and sees, well, who's on the land, that's good enough.
Yeah.
And might it then be said that the further provisions in paragraph 105(6) are where that, if you like, primary objective of the code, easy workability, doesn't work for some reason. Yeah. And then you're driven back to alternatives, and then it has to get a bit more complicated because you have to look at the rights that people might have.
Well, Lord, I can see that point may be put against me, and I'm sure the point will be put against me.
I think I picked it up from the Claimant's case, among many points. But
I mean, I'd certainly go this far that if it was simply a factual question and excluded right to control, of course it would be easier. I entirely accept that. But also say that on my learned friend's case, he rather exaggerates the problem. And the first point is, the question is whether the person who is physically there has got a right to control, not whether it has sufficient interest to grant the rights to the operator. This is not about title to grant, it's about right to control. That's the first point that we make about this. And we say, in practice, it's not going to be terribly difficult. And the advantage of our solution is it excludes the squatter. There are good reasons to exclude the squatter. After all, if your lordships will recall, an agreement under paragraph 20 must include provisions for consideration. They're not discretionary. And it would be a pretty odd conclusion, we would say, if the squatter grants rights, grants code rights, and gets consideration for that. So just as in entirely different context and looking at the electricity legislation, it was held there that it didn't include squatters, so also we say it shouldn't include here people who don't have rights. But I entirely take your lordship's points that, other things being equal, it would be even more straightforward if one didn't need to look into the question of rights at all. What we do say is, in practice, this is unlikely really to be a problem. Someone's either lawfully in occupation or they're not lawfully in occupation.
Well, I mean, and even in relation to the squatter, the operator may approach the person that they believe to be in occupation. It may be that if one burrowed down, one might find out that they're a squatter, but they may, being in occupation, either think or maintain, I've got perfect right to be here, and they tell the operator that. I mean, but your approach at this stage of the argument is to say, well, you can't take what the occupier tells you at face value. You actually have to be dealing with someone that does have rights, so you have to go behind what they say to see whether they do or don't have rights.
Yeah. Right. I entirely see that, and I entirely take what Sir Andrew Morritt said as well, summarising the purpose of concentrating on the occupier here. Although one needs to understand that comment in the Bridgewater case in context. Before the old code came into place, when one had the Telegraph Act 1863, one required the consent of the owner, the lessee, and any occupier. So the reason for concentrating on the occupier was to limit it down to that one person. There's nothing said in those dicta for reference. It's page 2303 in the bundle, and it's paragraph 26 of Sir Andrew Morritt's judgment in Bridgewater. That there's no hint there as to what occupation means. It's just that one needs to concentrate on occupier because that makes things simpler. It's not a case where, under the Telegraph Act, it was only the occupier who had to have a right of occupation, and it was felt that needed to change to only limit it to factual occupation. And we say, in practice, this really is not going to cause huge difficulties.
Well, presumably these operators do a degree of due diligence before they invest tens of thousands of pounds in installing a mast.
Yes. I suspect it's rather more than tens of thousands of pounds, my lady, but yes, however much
it's a lot more than a wooden pole and a bit of wire.
No. These are substantial long-term investments. They will want to know that they are dealing with the right people. So there is a lot of due diligence. It's, as I understand it, quite an expensive process as well. And there are, of course, negotiations going back and forth and solicitors, etc., involved, whether or not there's a tribunal application at the end of it. So it's, although I take my Lord Sale's point, absolutely, it would be easier. Being realistic here, they're going to be wanting, an operator is going to want to deal with someone who it feels has got rights to be there, and that's going to come out during the negotiations, given the investment that it's going to make.
I was just wondering whether a point in your favour would be going back to the discussion we had this morning about the effect on superior land owners in respect to the site, where the operator with code rights will want to make those rights stick against the superior landowner under paragraph 10.4. So they will have an interest to try to find people with superior rights in order to ask them either to agree to respect their code rights or to make an application under paragraph 20.
They'll either want to make sure that they can get rights against the superior landlord under paragraph 10.4, or if necessary by an application under paragraph 20, or they'll want to be sure that they come within paragraph 37.4. Your Lordships recall that's the provision that says that a superior landlord has got no right of removal if the rights were granted by its tenant otherwise than in breach of the agreement.
I'm sorry, just give me the paragraph number again.
37.4.
Yes, thank you.
So, Lords, we say, being realistic, that this makes, frankly, perfect sense. Then I was going to... there are a couple of other provisions in the code that appear to contemplate a difference between a person... that appear to contemplate that a person in occupation has to have a right of occupation. I don't put these at the forefront of my argument, but can I refer to them? Page 1815. Sorry. Is that right? Yeah, 1815. And it is paragraph 10.2c. So the context is when is a successor in title of an occupier bound? And it binds, amongst other people, under C on page 1816, any other person in occupation of the land whose right to occupation was granted by O. Now, my learned friend says, quite rightly, that one could read that as saying, well, only if that person has a right of occupation. I agree, that's why it's not the strongest point in the world. But there is a point to be made because it doesn't appear to contemplate that the person in occupation doesn't have a right of occupation. That's the point to make about that. Similarly, there's the same point in 10.5c, exactly the same point, right of occupation. And then one final provision, which is 23.5, which is 23 starts at 1822. And this is about what provisions have to be contained in an agreement. And the terms of the agreement must include terms the court thinks appropriate for ensuring the least possible damage is caused by the exercise of the code rights to persons, A, who occupy the land, but also, C, are from time to time on the land, And the distinction is being made between those two. Perhaps the distinction is to occupy the land, you've got to have a right to occupy the land. Squatters would fall within C, not within A, we would say. So those, I think, are the only other provisions of the code that we think might offer your lordships any assistance on the question of whether my second argument is right. I want to turn, if I may, briefly to the facts of the Compton case. This only applies, if I'm right on this argument, to the facts of the Compton case. And can I summarise those and then take your lordships to, I think, a passage in the statement of facts and issues. So the position in Compton is that Vodafone had a tenancy at will that was terminated before the 28th of December 17. Notice was served on it by Compton Beauchamp, the landowner, under paragraph 21(2) of the old code, requiring it to remove its ECA. And Compton then started proceedings against Vodafone for possession. The consequence, again, may be useful just to go back to the old code to remind oneself of that. Page 1921. So 1920 is where paragraph 21 starts. Notice is served under 21(2). The consequence under subparagraph 9 at the bottom of that page is that the ECA kept installed shall, except for the purposes of this paragraph, without prejudice to paragraph 6.3 and 7.3 above, be deemed against any person with the title required to the removal to have been lawfully so kept. So the ECA was lawfully there. However, Vodafone had no right of control over it. It didn't even have a right to access it. To acquire such rights, it would have to make an application under paragraph 6.2, which it had not made. To remind you, lordships, of that, page 1908.
Under which paragraph?
6.2 of the old code, page 1908, where it could have made an application, but the application would be limited to rights to so that the service could be maintained and the apparatus properly adjusted and kept in repair. But it did not make any such application. It is right, as my learned friend pointed out in his submissions, that Vodafone claimed in the possession proceedings that it was a periodic tenant, but that contention was wrong. And then, with that preamble, can I go to a couple of paragraphs in the Statement of Facts and Issues? That's at page 90 of the bundle. It's just two paragraphs I'm going to invite you, the lordships, to look at. The first is paragraph 22 on page 90. Which says, in mid-2018, Gately Hammer, who'd been retained by the appellant, which was managing the site on behalf of Vodafone, sought to access the Vodafone site and were told by the respondent's agents on more than one occasion that the police would be called if they attended at the property. The respondent does not deny that this occurred, but seeks to draw a distinction between the appellant and Vodafone. However, in the possession proceedings, the respondent asserted that Vodafone had requested access. And then over the page, paragraph 28, the appellant applied under paragraph 27 for temporary rights. This was necessary because Vodafone did not have a right to access the Vodafone site for maintenance of the ECA following termination of the tenancy at will. Furthermore, the respondent has indicated that the police would be called if access was attempted. So we say that this is a case where Vodafone had no right of control. It didn't even have a right of access. And therefore, if our second argument is correct, Vodafone is not to be treated as an occupation, even if our first argument fails. And therefore, there was nothing preventing Cornerstone making an application under paragraph 20 against Compton Beauchamp.
Well, making an application to someone other than Vodafone.
Yeah, to Compton Beauchamp. Yeah. Because if Vodafone wasn't, well, there's an obvious point, although something seems to have made of it in Malone Friend Skelton case, but in the Compton case, if Vodafone wasn't in occupation, it's pretty obvious it would be Compton Beauchamp. There was no other contender.
Unless it was Gately Hammer Limited.
They were just the agents, my lady. They were just the agents for Vodafone. So, if I'm right that Vodafone had no rights of occupation, and if rights of occupation are required to be an occupier within the first element of the cascade, then we move to the second element of the cascade, other rights of control or management, no one. Then we move to the third element of the cascade, it has to be Compton Beauchamp. Insofar as the orders is concerned, in Compton, the tribunal heard everything, heard the evidence and the terms and consideration and everything, but dismissed the application on the basis that it didn't have jurisdiction because Vodafone was in occupation, and so there was no jurisdiction on it to make a paragraph 20 order against Compton. If we're right on either our first argument or the second argument, then we'd invite this court to remit the matter back to the Upper Tribunal with the direction that it does have jurisdiction to make the order against Compton. That would be the only direction. It would be then for it to decide whether to do so, and if so, on what term. And while I'm on orders sought, in the Ashloch case, the only question before the court was a preliminary issue on whether a paragraph 20 order could be made, notwithstanding that there was a 54 Act tenancy in place. It was held that no such order could be made, and so the application was dismissed. We'd invite your lordships to order that the preliminary issue should be determined in the other sense, that is, in the sense simply that there is jurisdiction to make the paragraph 20 order. Malone Friend takes some point about, oh, well, that's right, how do we know who in fact the occupier is? Well, we say it's no doubt it's AP Wireless, but strictly there was only a preliminary issue that was determined, so if that's a point that he wants to argue before the Upper Tribunal, he can argue it. So that's what we say about that.
Could I just ask one practical question in relation to the Compton case? Vodafone is an operator with ECA on the site.
Yes.
It, as I understand it, would have what you've been calling the second bite of the cherry option to try to prevent removal of its ECA. Suppose Cornerstone is coming in as a new operator wanting to have code rights granted to it in respect of the site. And at the same time, Vodafone wished to resist removal of its ECA. Yes. How in practice would that contest be?
In practice, what would happen is there'd be two paragraph 20 applications. There'd be a paragraph 20 application pursuant to paragraph 40 sub 8 by Vodafone, and there'd be a freestanding paragraph 20 application by Compton. The reality one would expect is that the two applications would be heard together, and the Upper Tribunal would decide which of the rival operators should get it. and as your lordships know, whether I'm right or my learned friend's right, in theory, but only in theory, because in practice it doesn't happen, there can be applications by rival operators.
Yes, thank you.
But in practice, that's what would happen. Lord, the final thing, unless of course I can insist any further, I was going to simply set out, as I understand it, what the consequences of the various arguments are. If I'm right on my primary argument, it solves all the problems I identified. If I'm right on my second argument, it solves some of the problems, but not all of the problems. And dealing with those in turn. It solves the problem under paragraph 26 and 27, interim rights and temporary rights, provided that the interim, temporary, or temporary rights that are awarded under paragraph 26 or 27 are expressed to expire on or before the grant of permanent rights. Because once they've expired, then the operator's got no more rights, and so there's no objection to granting rights under paragraph 20. It deals with the problem under paragraph 40 sub 8, whereby a person subject to a right of removal, where an order is sought to enforce that, can nevertheless make a paragraph 20 application because that person has those rights. So far as voluntary removal of a Part 2 agreement is concerned, there's no problem because the old agreement continued under paragraph 32, under the continuation rights, can be terminated by agreement. Paragraph 33(4) tells us that. And if it's terminated by agreement and replaced by another agreement, then at that moment between termination of the old agreement and grant of the new agreement, the operator will have no rights. Scintilla temporis, if you like. So far as an operator with no 54 Act rights under an expired agreement is concerned, there's not a problem because it's got no rights. So far as an operator with 54 Act rights is concerned, then there's no problem if the existing tenancy is terminated by surrender or notice to quit. Code agreement can then be sought under Part 2 or Part 4 because it's got no rights. If a new tenancy obtained under the 54 Act, again, it will fall within Part 5 as the grant of the new tenancy will amount to a surrender of the old tenancy. So again, it's a scintilla temporis point. There are a couple of problems it doesn't solve. It doesn't solve the problem under paragraph 37(4). This, you recall, is the one where the reversioner, the superior landlord, says the superior landlord has no right of removal, where the land is in the occupation of a person who granted the operator rights otherwise than in breach of that agreement. It doesn't solve that problem, that if the operator is in occupation, then 37(4) can provide no protection to the operator, which would be an odd result. As to the acquisition of additional rights under the term, it would mean that that can't be done by an order under paragraph 20. Whether it can be done by agreement under paragraph 9, well, the only way that that would work would be if it's by replacing the existing agreement, and then the question arises, can that be done consistent with the continuation rights under paragraph 30? I'm sorry it's so frightfully complicated, but the gist of it is we're fine apart from 37(4), which is a really important protection for the operator, and the acquisition of additional rights during the term. I was also going to indicate, and I haven't compared notes with my learned friend Mr. Seitler on this, so he may or may not agree, as to the extent to which on Tower's arguments solve the problem, if your lordships wish me to do that. My learned friend, Mr. Seatler's primary argument, as I understand it, is that the relevant person is the competent grantor. That, as we see it, would resolve the problems under 26, 27, 40 sub 8, and also additional code rights during the term by order. But it doesn't resolve the problems under 37.4. It doesn't solve the problems of of a consensual renewal of a Part 2 agreement, because my own friend Mr. Seatler's argument is all about paragraph 20, what the court can order, rather than what can be done by agreement. Neither does it help on additional code rights during the term by agreement. It partly resolves the problem of an operator with no 54 Act results under an expired agreement. One wouldn't be able to get a new agreement by consensually, but one could do so by order. So one would be forced down the paragraph 20 route rather than seeking a consensual agreement. So far as an operator with 54 Act results rights is concerned, again, one wouldn't be able to do it by agreement. If the tenancy is renewed under the 54 Act, it still wouldn't fall within Part 5. It wouldn't solve that problem because the new tenancy didn't come within Part 2. But one could get a new code agreement to replace an existing or renewed 54 Act tenancy under Part 4. Mr. Seatler, I think, has his second argument is about paragraph 22 is a deeming provision, and I think that has precisely the same consequence as his first argument, as I understand it. His third argument is about deemed surrender and regrant, and that, I think, has precisely the same consequences as our second argument. Lord, I don't know if any of that is remotely clear. I've gone through that very, very fast, and I'm happy to go through that more slowly and in detail if it would be helpful.
Is that in your case, or is that...
Lady, I don't think that is usefully summarised.
Could we have it on 2 sides of A4?
You certainly can.
I think that would be useful, because I certainly wasn't able to take all of it down.
Yes, well, I'm not surprised. Your Lordship certainly can. We will arrange for that to be done, and it will certainly take no more than two sides of A4.
And if it's possible to agree with Mr. Seatler, that would be helpful. Then we'll know where we are. We will certainly seek to do that. Yes, absolutely. 2
sides of A4 is only intended as guidance, not as a compulsory.
Sometimes more is more helpful.
Yes, so
expressed too concisely.
Treat it as a short document.
I don't think it will take terribly long, but yes, if we could have the indulgence to go a little longer than that might be helpful. We'll certainly set it down very, very shortly, simply setting out what I've just said to your lordships and why. Anything else? Lords, my lady, unless there's anything else I can assist on, those are my submissions.
No, thank you very much, Mr. McGee. Just to give you fair notice, that you've used up, at least technically, 40 minutes of your reply time.
I appreciate that, Lord.
Thank you very much.
I knew there'd be a penalty.
Mr. Southler.
My lady, the on-tower case is perhaps simpler than either the Ashlock case or the Compton Beauchamp case. In my client's case, there's no complications with the 1954 Act. It's got its own ECA on site, not that of a friendly operator. There's no question of it being a subsisting agreement. And it has no rights under the old code, which has been repealed. This is just a case, a simple case of an operator already providing a service which customers and emergency services are using. And the effect of the Court of Appeal decisions in Compton Beauchamp and Ashland, and the reluctant decision of Judge Cook at first instance, is that my client is barred, in respect of this site, from having code rights precisely because it's already providing a service, and only because it's already providing a service. And given that the code came into force well into the evolution of digital technology, so it was imposed on a country that already had many thousands of masts, we say Judge Cook was right to find that a baffling conclusion. Why would an operator have been intended by Parliament to be in a worse position under the code because it already has ECA on site than if it was coming to it new? It just doesn't make any sort of sense. And we say that the legal outcome that my learned friend Mr. McGee seeks, which is that an operator in situ can apply for code rights through Part 4, is correct for the reasons he argues and for two other reasons. Two other reasons which offer your lordships a quite different analysis and a quite different perspective, but the same destination, the same outcome. We agree on the problem, but we're offering your lordship a wider palette of solutions. So, my lord, all I was going to do was to, first of all, highlight two aspects of the code that, with respect to my learned friend Mr. McGee, he's perhaps understressed, and then show your lordships these two other routes. We say there's two aspects that my learned friend Mr. McGee understated. The first is about the nature of these code rights. If your lordships look at them once again, page 1814, paragraph 3. There's a couple of things to notice that when you really stare at them, do jump out. The first thing is that more than half of them expressly assume the conclusion that the appellants seek to prove. So, not A, but B. Let's start with B. So, reading from the top, for the purposes of this code, a code right in relation to an operator and any land is a right for the statutory purposes, and then B, to keep. The verb is keep, to keep it there. So, keep assumes it's already there. And then C, to inspect. Well, you can only inspect something that's already there. Maintain, adjust, alter, repair, upgrade, or operate ECA, which is on, under, or over the land. The actual code right is assuming it's already there. Not necessarily D, but the third one is E. To carry out any works on the land for or in connection with the maintenance, adjustment, alteration, repair, upgrading, or operation. Again, you're assuming it's there. The very code right itself assumes it's already there. 4, to enter the land to inspect, maintain, adjust, alter, repair. You're assuming it's already there because there's no point entering the land to inspect ECA if it's not already there. 5, to connect to a power supply. Well, that must be for existing ECA. So, out of the 9, A to I, there's 5 of them that the mere nature of the code right dictates the legal outcome that both my learned friend Mr. McGee and myself are saying must be right. the nature of the code right itself is telling us the answer we have to get to. It must be the case that an operator in situ can get code rights because the majority of these rights actually envisage the existence of ECA in situ. They're actually envisaging you can apply for these rights whilst already having ECA on site. So the assumption of ECA on site is built into the nature of the majority of the code rights. That's the first thing to notice about these rights. The second thing to notice is that they can be sought not just by occupying operators, which is the first point, but also against non-occupiers. Even people who are not owners of the land in question. So nothing in paragraph 3, for instance, precludes the operator seeking code rights from the owner of the next door neighbour property. In fact, in the opening line of 3, the reference is to, at the end of the first line, any land. For the purposes of this code, a code right in relation to an operator and any land. It's not just the land that's perhaps been leased or licensed or whatever to the operator, it's any land. So that's fortified by the use of an expression in 3 of these rights, D, E, and F, at the very end of each of them, or elsewhere. Or elsewhere. So D is a code right to carry out any works on the land for in connection with the installation of electronic communications apparatus on, under, or over the land, or elsewhere. And that repeats in E and repeats in F. So we're talking about a right, actually, a code right, actually, in relation to someone else's land, not the land that's the subject of whatever grant there is, somewhere else. And then there is a particularly stark example at H. H is the right to interfere with or obstruct a means of access to or from the land, and it's whether or not any ECA is on, under, or over the land. So you could add H to the 5, we noticed, that assume the existence of ACA as perhaps a half. It says whether or not the ECA is already in existence on site, whether or not it's already in situ. Now, H is an interesting one because one can easily imagine a situation where, for instance, X has an easement, right-of-way, over the landowner's road. And the operator needs to block it for a telecommunications-related reason. Now, in that situation, X, as holder of the mere easement, isn't in occupation of this land, but nevertheless, the operator can seek a code right over it, even against the non-occupying owner, the holder of an easement. So, what's the significance?
Sorry, you saying that the operator would need to seek a code right from X, or that he can get a right and override X's?
He would need a right. He would need a right. He would need a right from X, or have X bound.
Yes, we wouldn't need a right from X. He could override X's right by being given a right to interfere with it.
He needs a right under 9 or 10. He needs X either to have conferred the right or to be bound by it.
Ah, yeah.
Even though X is not an occupier, it's just the holder of an easement. So, okay. So what's the significance of this? The significance of this is that what we say is that the nature of code rights is what shows the answer to the problem, and which is the key to understanding the code and unlocking it. And I speak as one, but the natural inclination of property lawyers is to impose a property law analysis leading to a property law solution over everything. And what we say has gone wrong below is an overlinkage of code rights and property rights, especially, or in particular, code rights and rights of occupation. Because the focus has been on whether a landowner or an operator is in occupation or is not in occupation. Whereas the focus should have been on the nature of code rights, because when you look at 3 carefully, in fact, it's not about occupation, and rights can be imposed on non-occupiers and can be sought by people who are already in occupation.
So just before we leave that, I wasn't sure why you left out I, because that seems to fit with your thesis as well. That's the lopping of the trees, but those trees could be anywhere.
Those trees could be on the land that's the subject of a grant. Well, yes, indeed, my lord. They could be somewhere.
Okay, I just wanted to check you hadn't left it out for some reason I couldn't understand.
The lopping of the trees, my lord, which your lordship may think stands out somewhat in the list, is because they can block.
Sure, yeah, they
Yes,
might be half a mile away or something, I don't know.
Oops, I was wondering the same thing, because they could be, as you say, quite a distance away.
Indeed. Indeed, my lord, they could be.
It's just creating the directness of the signal.
Indeed.
Yes.
Indeed. So, my lord, it may well be a clear majority of these code rights can be sought against people not in occupation and can be sought by operators who are already in occupation, and indeed only makes sense on the basis that the operator is already in occupation. So, my lord, we say one has to start thinking about this difficult subject by decoupling code rights from property rights. And that shouldn't be that difficult, because not all code rights are going to be connected with occupation. Often a code right is in practice coupled with a property right, but it doesn't have to be by any means. And operators, during the currency of a written agreement, which includes a lease or license, or after it's expired, may also need new code rights and not necessarily need new rights of occupation. They may be happy with their rights of occupation, but will need new code rights as technology improves. So we start this by saying we have to keep the proprietary rights separate in one's mind from the code rights. And that's why Part 4 doesn't mandate the type of agreement that the Upper Tribunal can impose. It doesn't say it has to be a lease or it has to be a license or anything. It just says in 20 subsection 4, what it's imposing is an agreement which confers the code right or provides for it to bind the relevant person. It can be an imposed contractual arrangement. And, my lords, what we say is that it's much easier when you decouple the property right from the code rights to see the true meaning of relevant person, and that there's no reason at all why the operator in situ should not be able to use Part 4, and indeed there's every reason why it should be able to. So, my lord, the first thing that we thought that my learned friend Mr McGee may have understated was the nature of code rights in 3.
The code rights override property rights. Is that in effect? I mean, if you have a code right, you don't have to bother about whether you have a property right. You can do what you need to do.
The code right is the destination. The property right is the vehicle which takes you to that destination, and you can get to that destination in a number of different vehicles.
And you need to be able to override people who have property rights.
Indeed.
That's
also
one reason why you have paragraph 10(4), as I understand it.
You need to be able to get to the destination and it'll take a car. But you can have different types of car, and that's...
Right. I've lost the metaphor.
Entirely mindful, my lord, I pushed it just that bit too far. So, my lord, there was one other aspect which I can deal with quickly, perhaps before the adjournment.
Just before you go on to that, I mean, isn't a central difficulty with your argument that paragraph 9 does lock in the occupation with the rights, the code rights, in terms of there being an express agreement, or in terms of being agreement. I mean, I can see what you're saying about Part 4, but you might say, well, Part 4, it would be odd if it somehow contradicted paragraph 9.
My Lord, I accept I have to accommodate paragraph 9. We think paragraph 9 is about new sites. That's really what it's about. Certainly it's where a code agreement is consensual, because we know that part 2 is about consensual conferment of code rights. And this is about where a code right is conferred consensually, and the assumption in there is that it's being conferred on an operator coming new to the site. It assumes an occupier who isn't the operator, so it's assuming that the operator is coming to the site new. Sometimes it's called greenfield. I don't know why. It doesn't have to be a greenfield. It could be a rooftop. It could be anything. But we say that 9 is in reality limited to the consensual conferment of new rights in respect of a new site that the operator is coming to fresh. And that's the assumption built into that.
And I think it can fairly be said against you. It doesn't say that.
No.
I mean, it seems to be completely general.
It seems very, very general.
It is general, and also while in 3 it talks about installing equipment on the land, and elsewhere, as you in other subparagraphs D, E, and F, it talks about the land or elsewhere. While in 9 it just talks about the occupier of the land and the operator, but presumably where you are dealing with a code right over elsewhere, you're dealing with the occupier of that elsewhere land.
Indeed, what is?
Yes, and in that case, you could have a situation where the operator was already on certain land, but he's getting a code right in respect of other land, such as lopping trees.
Indeed, my lord. And in that situation, the problem created by the Court of Appeal, if I may put it that way, is not a problem.
It isn't a problem, no.
Because the operator is coming to that other land, the trees some way away, fresh, as it were. It's seeking a right for the first time in respect of that other land.
Yes, but you're having to read into 9, this is the point I'm getting to, that it assumes only in relation to the land on which the ECA is located, that this applies only to a person coming new to that land.
Indeed. My Lord, we entirely accept that. We say that what 9 is doing, pretty subliminally, but is doing, is assuming an occupier who isn't the operator.
Not sure how it does work in relation to, say, a code right to lock trees. You might want that to happen lots of times. You might need to have a series of agreements for that. But you seem to be saying it only applies even to a lopping the tree agreement the first time you ask for it.
Well, in the lopping trees, the operator is never going to be
I follow that, but the reason I'm asking is because you've sought to say paragraph 9 is just concerned with the initial grant of code rights in respect of some land. And I mean, I think it's a development to the point my Lord Hodge was putting to you, that it's not just, it may be different land, it may be that you want us to keep repeating the application for code rights.
My Lord, thank you. May I rephrase it then and say that what it's assuming is that someone else other than the operator is a competent grantor. In the vast majority of cases, that is going to be because the operator is coming to the site new. It's a new site. But it's assuming, we say, that the competent grantor is someone else. It's not really grappling with the possibility of the occupier being the operator.
So the problem really arises because this provision in paragraph 9 is then incorporated by reference into lots of other agreements which are doing completely different things.
Absolutely, my lady. Absolutely, my lady. This property concept here, in relation to occupation, has been allowed to spread its tentacles right the way through the rest of the code, which is... And the code doesn't require that to be done because it's about code rights, not property rights.
Yes, so all you're really saying is that, as I understand in paragraph 9, there is an assumption that there is an occupier of whatever the land is other than the operator.
Yep.
Yes.
Because it's assuming two different people, because we always have two different legal persons as parties to agreements. My Lord, I was going to go on to look at another aspect that my learned friend had we say, understated, but I'm entirely in your Lordship's hands.
Well, it's after 4 o'clock now. I understand that you have time to cover the ground you need to cover. I think this would be an appropriate point at which to adjourn. Thank you very much.